Is this Act going to come in on the 1st of April? Because there appears to be a little bit of confusion whether everything's going to be in place in time for that.
As far as I'm aware and as far as everyone else is concerned, the thinking is that it is going to become effective on the 1st of April. The DTI and the Minister has been very adamant and consistently communicated that it would become effective on the 1st of April. And also we've had a long period to prepare, so despite all the amendments, the substance of the Act hasn't really changed. It's just been refreshed, to put it in that way. So all indications show that it would probably be the 1st of April.
A long time to prepare for what? What are we looking at here? What big changes are coming through in this Act?
Implementation of about everything. If I can run through a few changes, for instance, new companies will have to adopt a memorandum of incorporation. Currently they have articles and a memorandum. Those documents will have to be converted into one single document. Also, you'll have to bring your current documentation into line with the new Companies Act. It might conflict on a few issues, and also your shareholders agreement.
Are the requirements onerous for companies?
I won't really say onerous. In directors' liability, there's been a lot of speaking that it increases directors' liability. The actual thing there to note is that directors' duties and the standards expected of them remain exactly the same. It's just there are no more, not many offences anymore as under the current Act, but there might be more civil liability instead of creating an offence.
Is this being seen as progressive legislation for South Africa?
Definitely. One of the aims of the Act is to bring our company law in line with international trends. So examples of those are the business rescue provisions that was in the US legislation. I think it was called the Chapter 11 insolvency procedure. Also, we've adopted a defence for directors called the business judgment rule. That's a defence that originated in the United States. It's a defence that would aid directors if they became informed about the matter, thought rationally about it, and didn't have a conflict of interest.
How about red tape? Because that's often criticised as being a stumbling block to investments in the country, that there is too much red tape that you have to go through when you're setting up a company. Has that been streamlined at all?
I think so, because for the first time in South Africa, our Companies Act includes corporate governance provisions now to investors and about any other relations that you have with your stakeholders. Governance is a very important factor, and that's also, it might be burdensome in the beginning, just getting procedures and processes in place, but in the long term, it would make companies more effective. A well-governed company is always very good for the economy.
The new Act also seems to give a bigger voice to minority shareholders. Is this being seen as positive for investors in companies and also for other stakeholders?
Look, on the one hand, there are a few new provisions that protect minorities. There's a dissenting minority right that if a minority does not want to go along with a big transaction, he can force the company to buy his shares back at a fair value. And there are other provisions that minorities can invoke in M&As, for example, to ask the court to review the procedure. Now that's where people are concerned that it might too easily be invoked and that minorities may just strain M&As. But on the other hand, the Act sets quite stringent requirements to meet, so a vexatious litigant won't really be successful in an action like that.
Is this being seen as a work in progress at all? Because we know that some of it's been taken from the King Codes on corporate governance. We know that those codes are being updated all the time. Do you think we'll see further changes to the Companies Act going forward?
I have no idea, but it has been a great leap. The current Companies Act says nothing about governance, so it's already been a great step. So maybe not immediately, but maybe in future, in a few years from now.
What sort of teething problems would you envisage coming from implementation of this new Act?
I think it's just the technicalities. On the 1st of April, if you all of a sudden have to file documents with what it's called now CIPRO, that's going to change to the Companies and Intellectual Property Commission. It's just the technicalities, the new forms, all of those type of things concerning transactions and dealing with CIPRO.
And any concerns on your behalf?
Not really, except for the administration and whether these new bodies would be able to cope with the load, because all of the companies will have to incorporate the MOI and everything else that goes along with that. So it's just really to see if the admin bodies could actually deal with this load.